An NDA, or non-disclosure agreement, is an agreement to treat certain information as confidential or proprietary, and only use or disclose it in agreed-upon ways. What is proprietary information? Non-public information that gives you some competitive advantage. For example, design details, business or marketing strategy, prospect lists, or competitive intelligence. Typically, you would only share such information when you need help from others outside of your company to achieve your goals. There are two reasons to execute an NDA. Number one, to establish a common understanding of the proprietary nature of the information and limit its use or disclosure. And number two, to cover potentially patent protectable information before you file a patent. Here are three practical guidelines. Number one, assume that the NDA will be violated and that your information will leak out. Do not rely on an NDA as a legal tool to force compliance. For early stage entrepreneurs, this is simply not practical. Number two, disclose only what is necessary and only to those who need to know. For example, if you are engaging a third party to manufacture a component of your widget, only share details of the component, not the entire widget. Number three, in the case of proprietary information that could be patent protected, consider an NDA as a safety net of last resort, and whenever possible, file at least a provisional patent application covering the information to be disclosed before you disclose it. In the next installment, we'll consider the anatomy of a typical NDA.